Hello and welcome. Today we're going to talk about everything that you want to know about contracts but were afraid to ask. This is a topic that gets talked about or should be talked about more regularly than it does. It's important because at the end of the day, the very basic part of business is a contract. If you're new here, my name is Taylor Darcy from Think Legal, where I help you create the business of your dreams. So welcome. I'm grateful you're here, and I'm grateful that you take your time, your precious time, to spend it with me. Also, don't forget to hit subscribe and like. Hit that bell icon to be notified of when I go live every Monday through Friday, except for holidays. Please tune in to get your questions answered, and we look forward to meeting you and getting to know you in whatever capacity you need. Number one, contracts are literally like the foundation. Contract law, I should say, is the foundation upon which businesses are built. The very function, the very nature of a business begins with the contract. And then that contract begins either with the county in a DBA sort of situation or with the state, with the Secretary of State. And so you begin that by contracting with the state, saying, I am going to be this type of entity if you're going for an LLC or a corporation, or you're going with a DBA, which is saying, hey, I'm doing business as something other than my name. I want the county to know about it. So when people are afraid of contracts, it's very important that you recognize that contracts are everywhere and they don't have to be scary. Put that out of your mind that this contract is, oh, I don't want to worry about entering it. I don't want to worry about a contract because that makes it too formal, or that's just the way they get screwed. I mean, those are some of the negative stereotypes that contracts get. And in this video, we're going to talk specifically about some of those and let you know, give you a better idea of how to handle a contract so that when you're looking for help, that you're being an educated consumer as opposed to an uneducated consumer that could hurt you. Contracts don't have to be scary or difficult. They can be very simple. They don't have to have a ton of language, especially a ton of legalese. In fact, courts frown on legalese because of how confusing it is and how out of date it is. Contracts have made a shift over time from being very confusing and very legalese to where courts favor contracts that are simple, to the point, and contain all of the provisions that are necessary to protect the parties, not necessarily with legalese and that you have to have a law degree to interpret a contract. The plain meaning of a contract is usually where courts really like the contract to be. So the basics of a contract are you want to have an offer, acceptance, and consideration. Those three things are the foundation of all contracts. Without one of them, you have no contract. An offer is me saying I'm going to do something in exchange for something, okay? And that something is the consideration part. Consideration is something that you have a legal right to. For instance, I have a legal right to my time. I have a legal right to my money. I have a legal right to, there's lots of things that I have a legal right to. So I can exchange time and money for other things. And that's really the heart of most contracts. Now, on the opposite side of things, you have a right to the good that you're looking at selling. For instance, if you're selling an iPhone, well, Apple has a right to own that iPhone, right? They've manufactured it, they've built it. So that consideration is an exchange. That's the exchange. There has to be consideration, except for some extreme instances, and we're not going to talk about those. But for a very basic, simple contract, there must be offer, acceptance. I have to accept that we're going to do this contract, and consideration. Those are your basics. So to be very simple, that's all it takes to make a contract. So that's another reason why you shouldn't be scared of them, because it's so simple to do a contract that it shouldn't be one of those things that you're fearing because of how difficult it could be. A good contract should be fair and balanced to both parties. A contract that is too one-sided can be called what's a contract of adhesion. And a contract of adhesion simply means that there's unequal bargaining power in substance or in procedurally. So think of Verizon negotiating with the local company. There could be a contract of adhesion because there's no choice involved. Now, these are exceptions to a basic contract. So I just want you to keep in mind that good contracts are fair and balanced. You want to make sure that it's not too unfair to either party and that it's not too difficult to perform, because then it creates another thing. The next part of a good contract is that you want every contract to be a custom contract with clear and definite terms that avoids vagueness or ambiguities that creates confusion. So if you're wondering if it should be in the contract, the answer is probably. A contract that doesn't contain enough language to be clear about what it's contracting runs into the difficulty of it being too vague. And in that instance, the other party may be able to get out of the contract for that reason. You want to make sure that it's clear and definite terms. If something is important, it needs to be in the contract. And that leads me to my last point. If it goes without saying, it usually goes better with saying. One of my previous law professors used to say that, and it's such a great phrase. Because at the end of the day, if it's important, you want to put it in that contract. You do not want to leave it out. I've had several clients where clients have made a choice to leave something out of the contract, even though it was important, and they ended up in court because of it, because they chose not to put it in the contract. And so it becomes language that is the parole evidence rule. Simply, the simple version of it is that outside information can only be used if there's potential for fraud. Otherwise, whatever is in the four corners of the contract is what matters. And so if you leave it out, then the court's going to assume you intended to leave it out. So they're not going to hold you to it or hold the other party to it. So it's very important that you're making it very clear in your contract what it is, the expectations of both parties. That's one of the reasons why you'll get on websites where people will have a terms of service that are insanely long because of that factor. They're making it so very clear, but it's clear for one side, and you could run that risk of contract of adhesion. If you've gotten value out of this video, don't forget to hit subscribe and like, and we go live Monday through Friday at 11 a.m. We'll see you later. Take care.